অনেক সময় একটু অনেক করেছে একটু বস এটা আমাকে শুনতে আরে 2 মিনিট এখন একটু
Mr. Bandyopadhyay.
হ্যাঁ
Yes, you start.
my lord kindly see I just tell you lot my lord kindly see you will give the answer you will
I'll hear you later. Yes.
my lord kindly just I take your lordship from the very basic thing let us tell your lordship the facts 2016 in selection there is a panel
You are representing whom?
I'm a SSC panel prepared is who are unsuccessful those whose names are not in the panel correct in the panel those names were their panel High Court directed to make a CBI inquiry right from there tainted untainted categorization have come these disqualified persons in their cases it has not been done
Yes, this.
these disqualified persons whether tainted or whether untainted nobody knows what has happened ultimately entire selection process is gone their selection process is gone also those who are selected their selection process have gone also therefore all selection process has gone what the Supreme Court has done all appointments are set aside first order I'm coming later all appointments are set aside whether tainted would remain or untainted all appointments are set aside what is the consequence nobody in the employment from the selection process is illegal whether unqualified or qualified their cases are not scrutinized their cases have been scrutinized selection process itself is set aside as tainted selection process has been set aside as faulty no right to them no right to others on the date of the milord first date of the judgment that is that is the page 3rd April Supreme Court judgment let me read the judgment that will give milord kindly see the 3rd April judgment কত page আমার এখানে দাগ দেয়া আছে দিন kindly come to paragraph first 75 milord it has been set aside it has been shown to your lordship I don't need to require to show all have been set aside now your lordship kindly come to first paragraph 70 আরে ভাই তুমি দাঁড়াও না ভাই তোদের এক দোষ হয়েছে ওখানে হচ্ছে শামিম আর এখানে হচ্ছে তুই
Yes, Mr. Bandyopadhyay.
kindly come to milord page first 46
Paragraph 46.
Yes. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violates Article 14 and 16 of the Constitution. As such, the appointment of these candidates are cancelled, all cancelled. Selection process is gone. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the examination process and results have been declared void. This is the order. No candidates can be appointed on the basis of that selection. Whether it's unsuccessful, whether tainted, whether untainted, no one can be appointed from that selection process. Not future selection process. Not future selection process. From that selection process.
How you are submitting this? Come to paragraph.
I just give me time. Give me time.
No, because we have to consider it in the light of the order.
I am coming, sir. I am coming. Just give me time, sir. Give me time.
We cannot attribute our own interpretation.
No. I am saying, I have my submission.
Yes.
I am my interpretation. Your lordship may accept or may not accept.
Court can ask Mr. Bandyopadhyay.
Yes.
For SSC that if this submission is found to be in teeth with the order of the Supreme Court.
Absolutely. I am coming. I am making first this judgment's first interpretation. I am saying on that date, I have started with the submission on that date of the judgment has been delivered. Therefore, on that date, everybody should go.
Yes.
And that I am submitting. Possibly I was not clear to your lordship. On that date, now kindly come 47. Type to 47 paragraph. Come to 47. Some of the appointed candidates who do not fall within the category of the tainted candidates, kindly see, may have previously worked in different departments of the state government or with autonomous bodies, etc.
That is not relevant.
In such case, all their appointments are cancelled. See, cancelled. But the candidates will have the right to apply to the previous department or autonomous body online service because their continuity in service. Paragraph 47 is specifically for
some of the appointed candidates who do not fall within the category of tainted.
correct. Those who are working in other department, they will go there and-
Repatriation was
and their and
even necessary by creating
superannuation and their continuity service has not been disturbed.
interfered with, right?
They are,
But that is confined to tainted candidates.
they are untainted. I am saying that is an
Yes.
untainted. This benefit has been given by the Supreme Court. Then kindly come to Miller, paragraph 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concession. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Kindly read this line. Only for the untainted candidates there would be age relaxation. But untainted candidates will not be appointed. That's not there. Tainted. So for the untainted candidates, age relaxation will be there. Age relaxation will not be for any other candidates excepting the untainted candidates. This sentence doesn't mean that tainted candidates cannot make application without any age relaxation, or this has not been made for the candidates which application can be made, even the who are unsuccessful, where selection process has been set aside. Kindly read this.
Similarly, other candidates who are not specifically
In our similarly, other candidates
who are
who are not
tainted
specifically
will
tainted
also be
eligible
eligible
to participate with appropriate age relaxation.
Yes.
Participate.
excluding tainted candidates.
No. No, my lord. No.
Yes.
But this is our.
That cannot be a clarification.
My lord, that is.
That clarification I didn't expect from Mr. Bandyopadhyay.
No. This is my
Yes.
clarification.
Yes.
This is clarification.
Yes, Mr. Bandyopadhyay. I am eager to
No.
get an explanation from you.
No.
Which is
My lord, your lordships may not accept, but don't be annoyed.
No, I am not annoyed.
Don't
I
be
am
annoyed.
Also expressing my mind.
No.
So that you can respond.
Yes, all right, but not with annoyance.
No, not at all.
Not at that.
But I am also seeing your annoyance not being permitted to make an argument within time. From
not being permitted to do.
Yes, you are saying that from 12:30 I have other matters. Allow others to.
Why you are mixing up all these issues? Then you could have taken it. I am stopping it.
Because accepting your submission and your request, I fix the matter today.
Correct. I am not saying so, but I expected also item 1 is finished. Item 1 I will argue. But your lordships will
all the matters, if separately matters are to
no.
Also appreciate
this is my lord, I am not come here to quarrel with your lordships. I am not come up to quarrel with you.
No, why should
I am not come? I am not. No. My lord, I am a very small lawyer. Why should I quarrel with a great judge of Calcutta High?
That knows everybody that you are a very small lawyer.
Yes,
but
I am very small judge.
That
great judge can that's all right.
Query.
No, of course, I am giving an answer.
Any senior advocate.
My lord, I am the
beauty of our constitution. Now the thing is this, Mr. Bandyopadhyay, paragraph 49, your submission is this.
Beauty of our constitution is this. If the judge does not accept the submission of a senior lawyer, then judge would become annoyed. This is not beauty.
No, I am not at all annoyed. This is a way this court generally responds. Yes. And at the same time, court also expects that there is no annoyance from from a senior advocate like Mr. Bandyopadhyay.
Why should I?
Because others are.
I am not.
Others are looking at you. They are learning from you.
No, I will not argue.
Yes, please proceed. Please,
my junior. No.
Yes.
No, I will not argue.
Please proceed.
Your lordship is making very caustic remarks.
Yes,
never anybody has made such a caustic remark.
Mr.
No, I will not argue. You are a great judge. I will not.
This court is eager to hear you.
No. You are so. I don't know. Days are changed.
Yes.
That much I can say. Days are changed.
So therefore,
my lord, kindly see.
Yes.
My argument is this will also eligible to participate with appropriate age relaxation.
Therefore, your argument is this in a short campus with regard to paragraph 49 is this: those who are tainted, they will not get age relaxation. Those who are not tainted, those who are untainted, they will get the benefit of age
relaxation.
That is
my argument. That is my argument. And whole rule is based on this. It's an open category. Open category. Now, as it would above these candidates to
just a minute.
Now, if you restrict it,
yes,
my lord, kindly see. If your lordship restrict it, just for an another view I am giving. If your lordship then only untainted candidates can apply. Neither tainted nor the unsuccessful candidates.
Couldn't follow. Yes, please repeat it again.
Let's assume that your lordships, if your lordships says only untainted candidates will apply, then in that case, my submission interpretation has to be given. Neither the tainted candidates can apply, nor unsuccessful candidates can apply, though otherwise eligible. Kindly appreciate this. That is the reason I have started with this. See, the inquiry was only for the panel candidate. Inquiry was not there for the unsuccessful candidates. We do not know who are tainted or who are untainted amongst them.
But is it required to enter into the this issue after the order passed by the Supreme Court,
After
specifically prohibiting tainted candidates from participating?
I am submitting. Here is no prohibition of any other person. No person is prohibited to make an application. This is my submission.
Now, your submission is that untainted as well as unsuccessful in 2016 selection process will not be permitted.
No.
If that is accepted.
If this interpretation is accepted, that only the untainted candidates would be given the chance with age relaxation, then tainted and unsuccessful candidates are also barred.
Why unsuccessful candidates?
Why not?
Clubbed with,
why not?
With tainted?
Why not? Did we make any inquiry whether they were tainted or untainted? Inquiry was tainted or untainted. They were unsuccessful. Nobody, kindly similar, just excuse me. At any point of time, unsuccessful candidates' fate was not discussed because they are not entitled to. If an interpretation is made, I am submitting, my lord. I am submitting that this with appropriate age relaxation means only in the case of untainted appropriate age relaxation. But it is open to all. But it is open to all. But it is, if it is interpreted that only the untainted candidate can make application of that selection process, then accepting untainted, neither tainted nor unsuccessful candidates can make an application.
Only simple question I am asking.
My lord, I will try to give answer.
In view of the order passed by the Honorable Supreme Court.
Oh, yes.
Or judgment of the Supreme Court dated 3rd April 2025.
Yes.
Read with the order passed on an application dated 17th April 2025. Whether tainted candidates should be permitted to participate in the selection process. This
is your question. Yes. I am giving you answer. Come. This is the only question. Nothing more than that. Now, what has happened? All termination. Effect of 3rd July order is a termination. 3rd July, no?
Yes, yes.
3rd April. Sorry.
3rd April.
3rd April, all termination. Tainted, untainted, all termination. Now, from April, there are vacancies. This untainted were not going on in the employment. Then who made an application? Board made an application. Not the state, not the SSC. What they have said, kindly allow us to to make the interview complete. Until that, kindly allow us to continue with this. For which classes? They have made an elaborate application. Now, what the Supreme Court said? Kindly come to page 86 first.
Paragraph?
Page 86 is the order. Let me read this.
No, tell me the paragraph because I am...
No, kindly from the top.
Order dated?
The order dated, that order what your lordship was referring to? 17th April.
17th April. Just. Yes, 17th April.
We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10, classes 9 and 12, not found to be tainted, subject to the following condition. We are ready to accept. Prayer for what? Prayer for continuation of their service until the selection process is made. That was a prayer by the board. Now, kindly read again. Kindly excuse me. Sorry, my lord.
Yes.
We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10 and class 11 and 12, not found to be tainted subject to the following
So that
conditions.
is according to you is this with relation to their continuation
Of service, not for any other
it has
reason.
been extended till 31st of December.
Correct.
Yes.
Those who are untainted, let us kindly see, Group CD they have not given. Group CB also tainted.
To that extent, there is an observation in this.
That's right. Group CB did that. Only for 9 and 10 and 11 and 12 continue with this service. That doesn't mean no, they will continue with this service till doomsday. No, they have to come through a selection process if they continue up 31st December.
But subsequent directions?
I am coming. Therefore, this is only for continuation of appointment, not for any other factors. Next, an advertisement for fresh recruitment to the aforesaid post. Post means 9 and 12. We have not done other, only 9 and 12.
9 to 12, yes.
9, 10, 11, 12. Subject shall be published before 31st May. We have done it. The examination and the entire recruitment process shall be completed by 31st December 2025. The state government, the appellant, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 2025. Enclosing therewith a copy of the advertisement for the fresh recruitment as well as the schedule, therefore, as so as to ensure completion of the recruitment process by 31st December 2025. In case the advertisement is not published and the affidavits are not filed by the court, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. Therefore, what are the risks were there? Risks were first risk to us, I mean to the board, that their employment will be terminated if 31st May 2025 is not done.
Whose employment will be terminated?
Those who have got this by this order
31st of December.
Up to 31st December. Their service will go. Second risk, cost. Anyway, we have done it. I mean, state done it. 30th rule has been published in the morning. 30th advertisement has been made. Because 31st May was the cut-off date. We have complied with the order. Therefore, my submission, kind of similar, why I am submitting. That's the reason I wanted to say, give me, I will try to. This may be accepted, may not be accepted. That's a different. Saying about that, no. Tainted have been totally discarded even by 31st May or this order, 17th July. This is incorrect submission. Factual position is this. They will be there. Only untainted candidate service will continue up to 31st. That doesn't mean that the Supreme Court has cut a bar. No. Tainted candidates will not be allowed to sit in the examination. Anyway.
After holding that there was an egregious fraud.
In the matter, my lord, can I say, since your lordship have said, let me take it. Since it is a fraud, their appointments have been terminated.
The direction to refund salary.
No. Please. Kindly read this paragraph again. Refund salary to whom? No. Refund salary to? I am reading it. Paragraph 45. Kindly read. The last question, paragraph 48. The last question relates to relief and whether it requires any modification. We find no valid ground or reason to interfere with the directions of the High Court. The service of the tainted candidates or appointed must be terminated and they should be required to refund any salaries, payments received such their appointments were the result of fraud. This amounts to cheating, therefore we see no aspect. Very nice. So correct. Your lordship is correct.
Yes.
Now,
so thereafter,
now let me explain. Let me explain. If your lordship read this entire judgment, your lordship will find it has been said that the Evidence Act doesn't apply. Correct. It's an inquiry naturally in a domestic in character. Whole inquiry. Charges have not been proved by anybody. It's a finding on the basis of these reports of the tainted, untainted. Court has not said the charges against them in a criminal court have been established. On the basis of a report on the OMR sheet, tainted, untainted has been given. Now, kindly see the judgment, paragraph 50. Our observation and findings would not influence the criminal proceedings. There was this observation for the temple was for deciding that matter, not for future decision. Why should I not? Is there any conviction? Is there any conviction? Under what law they should be debarred?
Mr. Bandyopadhyay, it is worse than dismissal from service.
Which one?
This observation and
Dismissal. When your lordship has come to this,
which would include
my lord, kindly see.
future disqualification.
No, kindly this.
Since the appointments were the result of fraud, this amounts to cheating.
Kindly see. Dismissal with no appointment should be given. It should be governed by a rule.
And by making an
My lord.
Rules dated 29th of May 2025, this tainted candidates have been permitted again to apply.
Yes,
and they have to get their marks for 10, which
I
has
am
been
coming,
allotted
one
for past service.
One by one, I have to come, my lord. I have to come one by one. First is the dismissal. When a dismissed service cannot get an appointment, if there is a rule, it has not been said dismissed from service, terminated from service. Compulsory retirement and dismissal is not same.
So that's why I have consciously used the terminology dismissal.
Therefore, this order has not been dismissed. Their services are dismissed.
Terminated for cheating and fraud.
Terminated. Cheating and fraud. With an observation, this observation will not influence the criminal proceeding. No conviction. There is a single case of no conviction. But this is our submission. Court, whatever the court will say, that's a different thing. That's a different part. This is our reading. We are saying we have opened the door for all. Let's
how that is permissible in view of this.
Why not?
How in view of this order?
Supreme Court has not said. Supreme Court has not said.
And moreover, Supreme Court has not interfered with the judgment of the honorable division bench dated April 2020.
Division bench judgment has been merged with the Supreme Court.
Yes.
Justice Bosak has already made an observation in content petition.
That is marked.
Our observation has been merged with
Supreme Court has not deviated from the.
No, Supreme Court has been. But Supreme Court has not said that the only unemployed, only untainted candidates will be given the chance. Had it been said, I would have accepted this. If it is interpreted, only untainted candidates will get the chance. In that case, neither tainted nor unsuccessful candidates will get the chance.
So what is the difference? If I accept your submission in connection with the observations made by the Supreme Court in paragraph 49, the difference in between tainted and untainted is for tainted, they will not get age relaxation.
Age relaxation.
For untainted, they will get age relaxation.
Why, Lord? I am saying, whole lot will not come.
In view of this, in spite of this observation of cheating and fraud.
My lord, yes, I have to read paragraph 49. I have to go by paragraph 49. What I will follow? I will follow the observation. Direction part I will follow. Whatever the direction is there, I have to follow. I cannot deviate from the directions. I am just following the directions. My lord, kindly excuse me for saying with great respect that if there are two interpretations are there, one of the interpretation, if it's right, that.
Now, another issue which is troubling this court, Mr. Bandyopadhyay.
My lord.
Come to this rules.
All right.
Dated 29th of May 2025. Rules of dated 29th May.
Prior to that, your lordship.
I will hear you.
Just one disqualification I will just show to your lordship. Our rule. Then I am coming. Kindly excuse me. 3.5. Rule.
Yes. Yes, 30th May 2025 is the notification and rule is 29th of May. Just a minute.
3 rules, sub rule 5.
Hey, you get it out. Just 8.
102. I am told one.
Just. Yes, 29th May.
Rule. 29. No person shall be eligible for 3 Roman 5.
3 Roman 5.
These are the disqualification.
Yes.
No person shall be eligible for selection for appointment unless he is a citizen of India. B. No person shall be eligible for selection for appointment if he is convicted by any court of law.
Yes.
Conviction, if there is a conviction. But not years together, 5 years, 4 years, matter would be kept pending in the criminal cases, and the citizens, boys and children of these people of state of West Bengal will be remain in a limbo condition. Is it acceptable also?
Now, Mr. Bandyopadhyay, please come to Schedule 1.
Yes, madam. 108.
Then Schedule 2, not Schedule 1, Schedule 2.
Schedule 2, 123. It absolutely. Yes, academic.
Then written marks, the marks which were allotted previously, that has been changed. Previously it was
kindly come to me that written examination OMR
previously it was 55 plus
now it has
35
been
plus
increased.
10. Now it is 60 plus 10 plus 10 plus 10.
60
Now, if court proceeds on the premise that it is within the domain of the recruiting authority to frame rules in rules, court will not enter into this issue. But what is pinching this court is this:
Yes.
come to Schedule 1, this prior teaching experience 10.
Matlab
Please see prior under Schedule 2, then capital A 1 2 2A, then 2B, prior teaching experience 10.
Yes.
Have you found?
Yes, prior teaching experience 10 marks.
So written examination 60 marks, then academics 10 marks.
Yes.
Then apart from 10, oral interview 10, lecture demonstration 10. Very good. Prior teaching experience 10. That these tainted candidates who have lost their job with by the dint of the order of the Honorable Supreme Court judgment dated 3rd of April 2025, with an observation that they are the product of cheating and egregious violations of the law, they are to get the benefit of this prior teaching experience.
Can I say?
Yes.
Mulad, if the question is, once you have tainted, then you can't get any chances in life, then it's a different thing. That you hold it. Once it has been declared tainted, this generation, these people will never get a chance to record it. I don't mind. I will say to that. But according to me, and this 10% rules is not a new one. It was earlier also there, pre-2006.
No, I am not questioning this rule. I am questioning that if these candidates are to be permitted by submitting application to be considered, then whether these tainted candidates are also going to get this marks of 10 for their experience in past service.
I hope your lordships know that de jure doctrine. Suppose a district judge appointment is dismissed or appointment is held null and void or cancelled by the judiciary, his judgment will go.
That whether the situation is equated with this.
I am talking about principle of law.
It's not a similar situation.
I am talking about principle of law.
When the Supreme Court in paragraph 45 onwards has specifically directed.
Your lordship hold it. I don't mind.
Directed.
Your lordship hold it. I don't mind. But I am. Kindly see. Let me be very clear to your lordships. I am open to all. It's an open category. Whoever will succeed, whoever will not succeed, they will get the appointment. So far, the age relaxation is concerned, only the untainted candidates will get avail. Neither the tainted candidates nor the unsuccessful candidates will get this chance. All the candidates will not get the chance, as if all tainted candidates are coming. No. Answer is no. Have they given in the petition? How many tainted candidates will get chances?
No, anxiety of the court is this, that the order of the Supreme Court has to be followed in its true letter and spirit.
My lord.
Where Supreme Court has said that these benefits are to be granted only in connection with the next selection process, which is confined to the, not in the same language, as it appears that it is confined to the untainted candidates. Then where is the bar you have claimed in your rules or in your notification that tainted candidates will not be permitted?
Milord, I do not read. Kindly excuse me, Milord. Just with greatest respect, deepest respect to your lordships, Milord. With deep respect to your lordships, Milord, I do not read the lines that the tainted candidates have been debarred to appear in the examinations. Tainted candidates.
Tainted.
I am submitting. Milord, my stand is very clear. My stand is, it is open to all. Open to all. Unsuccessful, tainted, untainted, everyone.
Very well, Mr. Bandyopadhyay. And I have noted your submission and any other point.
And kindly note that if it is said, so far 2016 selection process, only the untainted candidates will avail the opportunity, then tainted and unsuccessful, all are barred.
Yes, any other?
Can there be double punishment? Article 2020, Article 2021. Refund of salary has been made. Service has been terminated. Finished. No age benefit. Now, can they not sit in the examination with competition? Only these persons will be benefited. Those who are did not get the chance, because here they are the litigant. Only litigants will get the benefits.
These 2 points you have argued in detail.
Yes.
Any other point?
Any other points, Milord? I have to argue. If I have to argue to the rules is.
No, regarding, I am expressing my mind.
Lord.
So that in order to cut short the interview.
Yes.
Regarding this allotment of marks, and this 40-45% court will not enter. It's a policy decision. Court will not enter into this issue. What is troubling this court is whether the tainted candidates will be permitted to participate or not.
Yes.
That I am hearing. And please address this court on the point that how far this court can go with in view of the order passed by the Supreme Court on 17th April 2025 fixing time.
But first of all, Milord, kindly just excuse, since it's a discussion aware, your lordship is finally deciding the matter, or?
Yes, I will finally decide.
Okay. Now, Milord, my submission would be, I have made my first submission regarding tainted and untainted. The court will not interfere. If the court interferes, then the Milord, that 3rd July, 3rd April order will be interfered with. We will not be able to do it by 31st December, whatever it may be. And the persons who are appointed in view of the Supreme Court's order, they have to go. After 31st December,
if the time schedule is extended.
If your lordships can do it, can't do it.
No. Court will not going to extend the time schedule.
Then these questions we will not discuss, because it will be discussed in the Supreme Court. It will be discussed in the Supreme
Court. But certainly court can enter into the arena where court finds that a Supreme Court order is not being complied with in its
Sure. If your lordship strikes up,
entering the time schedule.
My lord, kindly see, if your lordship hold that this rule is bad, your lordship can strike it down. I am not saying that your lordship doesn't have the power. We have been asked to file an affidavit, we have filed the affidavit. There is a proceeding, Milord, pending before the Supreme Court under Article 32 of the petition, challenging the same rules. Filed on 10th June 2025. Details proceeding, the petition under Article 32 is there. And also an contempt petition has been filed. Whether we have violated the Supreme Court judgment order. The inquiry which your lordships are making,
that keeping this selection process alive in terms of the time schedule fixed by the Honorable Supreme Court, court can debar the tainted candidates from participating.
Therefore, your lordship invalidating the rule in another way.
In order to maintain, for the purpose of strict observations of the strict compliance of the directions of the Supreme Court.
Milord, that's your lordship. Milord, then in that case, your lordship, if your lordship hold that
that is what court is thinking.
Court is thinking
that because court cannot tinker with the. You are absolutely correct, Mr. Bandyopadhyay, that court cannot tinker with the time schedule fixed by the Honorable Supreme Court. And what you have said, that is also to be taken into consideration. If time schedule is extended, then these persons who are untainted and those who are appointed, whose appointment is extended till 31st, they will lose their job. So therefore, within the parameters of the order passed by the Supreme Court, as well as taking note of the steps taken by the recruiting authority relating to issuance of recruitment rules as well as recruitment notification, court can debar the tainted candidates from.
If your lordship doesn't accept my submission,
yes,
kindly accept one submission that accepting untainted candidates, no one can make the application. In that case, whether tainted or whether unsuccessful candidates.
Accepting untainted candidates.
Whether it is a tainted or whether it is unsuccessful, they also cannot make application. They cannot also make it because their party has not been scrutinized. Scrutinization only falls over that party. If your lordships, kindly excuse me, Milord, if your lordships holds it, although I have a total disagreement, with great respect, I have a disagreement.
That you can
I have with great respect, I have a disagreement.
Yes.
If your lordship hold it, that paragraph only gives the chance to the untainted candidates with age relaxation to apply. In that case, neither the tainted nor the unsuccessful candidates also can make the application. If your lord, but I am submitting, it is open to all, only
your interpretation in connection with paragraph 46.
Yes.
You have submitted.
Yes. And Milord, in that case, your lordships would be imposing double punishment. Already one punishment, termination, and the refund of the salary has been made. How many times these persons will be victimized? I mean, how many times these persons will be penalized? How many times? Your lordships have,
if they are the product of fraud and cheating,
they are the product.
They have to face the consequences.
No, fraud and product. That's the reason they have faced the consequences. Therefore, your lordship, if your lordship suggests that no, once you have imprisonment of 3 years, you are not entitled to enjoy any facilities of the society. Does it not violate Article 21 of the Constitution? My submission would be, once they have been tainted, their services have been terminated, they have been penalized to refund their salary. Finished. Chapter is finished. If they are no age relaxation, if they are eligible according to the qualification, I mean experiences, that the age criteria, they will sit in the examination. Thereafter, another things will be seen. These are my submissions.
Yes.
Only, Lord, I am very limited to your queries, lots of queries.
No, whatever I will go to that extent, I have indicated.
I have given the answer. I hope anything is left on. Anything
if I
is
go deep into the matter, then I will.
Of course, anything.
No,
If anything is left for your lordship that I have not given the answer to your queries, your lordship can ask me. I will try to. My point is very clear.
Yes.
Just give me the constitution. Give me one constitution. Just kindly give me 1 second. Constitution. Just give me one. Article 20 of the Constitution first.
Article 21.
Article 20, sub-article 2.
Just. Yes.
No person shall be prosecuted and punished for the same offence more than once. This is the constitutional philosophy. How a person can be punished for ever, twice, thrice, 4 times? How? Then, my lord, kindly come to 21A. The state shall provide, no person shall be deprived of his life or personal liberty except according to procedure established by law, under which law they are debarred to sit in the examination.
Yes, Mr. Bandyopadhyay.
বললাম তো আমি না সেটা বললাম তো আমি বলেছি the who cannot sit, that has not been said. If you again, please আমি বলেছি দেবাঞ্জন বারবার তোর একটা জিনিস রিপিট করছ। I have said, I have again, if 49 paragraph is read to this extent,
then tainted without age relaxation, untainted with age relaxation.
Yes, and only this.
If untainted, and the reverse situation is this: if untainted are to be allowed, then tainted along with unsuccessful are to be excluded. Yes.
Yeah. Yes. বলে দিস developed. Sorry.
No, why sorry? I have fixed the matter for you to hear you, and Mr. Bhattacharya as well as Mr. Mitra.